Welcome to the other side of Lucy Letby. In episode 50, we're going to continue on looking at this Court of Appeal judgment. The whole point of this for me is to see if I can put straight in my head the manner in which these lawyers create facts, which I find very bizarre on the face of it. So we'll remember what Justice Goss said when he was summing up, just so we can all be on the same page as to what I'm thinking, be it right or be it wrong. Remember, in paragraph 5, the appeal court judges stated that the defence had mounted a robust approach to the evidence. That was called. Well, it might have been a robust approach, but it certainly wasn't an effective one. And it's something that greatly concerns me. And then the rather chilling comment that, secondly, to make a somewhat basic but related point. So these people say that this point is basic. What was put to the prosecution witnesses, that's Barry Evans et al., in cross-examination was not evidence, save to the extent that it was accepted by the witness. What this says to me is that no matter what the defence said to the witness, if the witness wanted to act in bad faith, all they had to do to create a fact was to disagree with the defence, or indeed mislead the defence. For example, we have the Sandy Bowen central lines never migrate within 2 weeks lie, the Dr. J. Ram ET tubes only ever come out when they're intentionally dislodged lie, and then the contradictions. Professor Owen Arthurs, in the case of baby A, says that the line of gas in front of the spine was suspicious. But whatever it was suspicious of, it wasn't that he was implying, or embolism, because he goes on to clear that up in the case of baby E when he says that only an X-ray taken at the time of the actual embolism, not post-mortem, at the time of the embolism, that contained a large amount of air and that filled the heart with air met the criteria for diagnosis of air embolism by X-ray. But none of the Letby babies met this criteria, which begs the question, why was the X-ray suspicious? It was a post-mortem X-ray. So this is the type of dodgy fact that we're talking about here. And remember what Justice Goss said, that what counsel say to you is not evidence. They are advocates, not witnesses. Their role is to present their respective cases, to question witnesses and to advance arguments on the evidence for you to consider. So he says then that where a witness agrees with a proposition in a question, then it is the reply of the witness that becomes the witness's evidence. Where the witness does not accept the factual proposition in the question, then the question itself is not evidence. So on a really childish or basic level, what he's saying here is, if Ben Myers asked the defence, are you sure there's enough evidence here to convict someone for killing a baby by air embolism? And the expert witnesses say yes. And remember, expert witnesses are the only witnesses we have. Then that becomes evidence, which the jury go away and weigh up before they make their decision on guilt or innocence. So nothing said by Nicholas Johnson was evidence. The only expert that Lucy Letby called was a plumber, and that is the basis of a fair trial, or at least that's what these appeal court judges are going to say. So that begs the question to me, what would have happened in a situation where the defence had called expert witnesses who refuted every single thing that the prosecution witnesses said, essentially that there was nowhere near enough evidence to convict Lucy Letby or anyone else for the crimes that the prosecution alleged. The jury would then head off and they would at least have 2 opinions, expert opinions to consider. But that didn't happen, and we only have the jury considering facts created by the expert witnesses. So it seems to me that the only defence Letby had was an attempt to overturn the opinion of a string of expert witnesses by the power of persuasion alone, and by not putting into evidence contrary facts by way of your own expert surely you rob yourself of any opportunity to undermine the claims made by the prosecution at an appeal. Personally, I can't see the point of this strategy at all, and the proof of that is in the verdicts. Derry Evans was so outrageously partisan and quite ridiculous as a figure that he should have been relatively easy to undermine. I find it very hard to see how Michael Hall, the neonatal advisor to the defence, could have created a worse situation for Letby when he got into the dock to create facts. I mean, even simple statements like the pressure of that ventilator was high enough to kill the baby on its own. I don't care what Derry Evans says. If a baby goes 7 hours without dextrose, they're going to die. To quote Derry Evans back into his face, that's why we have neonatal units. I just can't see how leaving out your own expert is ever a good idea. It might seem a good idea at the time if you don't have confidence in these people, but they can create facts, and you can. And facts, certainly in science, are the basis of all evidence. Now we jump to paragraph 20 because the rest of it is just a description of the procedure. And paragraph 20 says in the background, between June 2015 and June 2016, there was a significant rise in the number of deaths and collapses at the hospital. And straight away, we have a big problem here. A critical piece of evidence, a report by the Royal College of Paediatrics and Child Health that tried to explain why these collapses were taking place, was ruled inadmissible by the judge on the basis, I believe, that it was hearsay. But the same judge didn't rule inadmissible the countless examples of hearsay given against Lucy Letby. For example, her alleged comment that baby P wasn't getting out of there alive, which had even happened, could have meant anything. Or Dr. Breary's observation that Lucy Letby seemed quite happy to work the following day after baby P's death. To me, that's just hearsay. No record of those comments anywhere. Would it not be a better test of whether or not evidence should be admissible in a trial of such public interest that a judge would consider any evidence that he thought the jury might like to see, such as this report from the Royal College of Paediatricians and Child Health? Certainly had I been a juror, I would have wanted to see that report. And paragraph 20 continues on to talk about the efforts made by the consultants to review these cases and to come to a conclusion as to why they were happening. And then it says that Dr. Stephen Breary and Dr. Ravi Jayaram carried out an informal review and found that Lucy Letby was the only person present when each of these events occurred. Why on earth isn't that hearsay? Because we know from the RCPCH report that the statistical chart that everyone says isn't important now wasn't constructed fairly or by any scientific method. So it seems to me that the Court of Appeal here is using the same flawed logic in their decision making. Breary and Jayaram were too close to the problem to ever be objective. The RCPCH told them they weren't being objective. They also told them that they weren't following the normal reporting rules and recommendations for risk and safety in the hospital. But yet that is deemed hearsay, whereas this informal review isn't. Someone will have to puzzle me that. Then straight away we get into chapter 21, where it says on June 21st, 2016, at around 4:24 p.m, triplets were born. One of the triplet, baby O, died on June the 23rd, 2016, and his brother, baby P, died on the following day. The applicant had been their designated nurse. Another baby collapsed suddenly and unexpectedly on the 25th of June 2015. By this stage, the concerns of the most senior consultants in the unit led them to remove the applicant from all clinical duties. That's not correct either, because the consultants didn't have the power to do that. The management removed Letby from all of her duties, and a very big fact is missing from chapter 21, which the defence could have put into evidence as a fact that at the time baby O died, the pressure at the head of the ventilator was so great that his liver was pushed down into his pelvis, and the consultant probably stuck a needle in his liver. Something that the expert witnesses who created all the facts in this case didn't want to mention. In 2017, April, senior doctors from the unit first made contact with the police. There were meetings with the police and the consultants on the 27th of April 2017 and the 15th of May 2017, which precipitated the police investigation. Now, one of the people making the complaint to the police during these meetings was the person who allegedly put the needle into the liver of the baby and apparently didn't realise what he had done. And another one, J-Ram, has since been criticised for being inconsistent by another appeal court judge. He didn't do anything about it. He just commented that J-Ram was inconsistent in what he said. When the truth is, if you really read the trial, is that every second line of this so-called evidence was inconsistent. And then we just have a repetition of the golden thread. Paragraph 22. During the police investigation which followed, Dr. Evans, a retired consultant paediatrician, was instructed to review clinical records of the babies in the unit who had died or collapsed suddenly. Initially, he reviewed 33 sets of clinical records where an infant had died or deteriorated and where the events were unexpected and or unexplained, except factually none of them are unexpected or unexplained. Something which should have been relatively easy for Professor Hall to establish or at least create serious doubt about. And then it carries on to say that Evans was later sent a further 28 set of records for review. That's now 62 cases all in all. The purpose of the review was to consider in each case the cause of the collapse of the baby. He produced a very large number of reports, including a general statement dated 17th of April 2019, setting out his background and experience and a glossary of terms, a review of published literature regarding our embolus, there's that word again, in newborn babies, dated 3rd of July 2019, and a series of reports considering the events surrounding the deaths or collapses of babies who were the subject of the charges. Dr. Dowie's list of publications, I think he said he had 19 publications. So far, I haven't seen the light of day. I don't know if they ever will. But all of the publications of the hundreds that have been written about our embolism in preterm neonates and in babies in general list more than one etiology, that is, origin of an embolism in a baby. Every single one of them will say that there are at least 2 or 3 common causes that can't be distinguished one from the other. And none of them will make the claim that a physician can diagnose embolism in a baby by the Evans test, skin rash, sudden collapse, failure to respond to resuscitation. Because again, there are a legion of reasons why this can happen in a neonatal unit, and it is impossible to distinguish one from the other, even at postmortem. And then Section 23, Dr. Evans remained the lead expert throughout the investigation and trial, even though he wasn't qualified to. His conclusions were peer-reviewed by Dr. Bowen, a currently practicing neonatologist from Guernsey. Her specific instructions as set out in her report on Baby A of November 29, 2020 were to peer-review the work and statements submitted by Dr. Evans using his statements, additional material and access to the same medical files he used in forming his opinion, to provide Section 9 statements of those reviews conducted in a thorough and transparent manner, to continue to assist the investigation in answering the question of what happened to each baby. And I think we'd agree that after Mark McDonald's press conference, it doesn't look like she did a good job at that. And to provide, Bowen, had to provide detailed explanations of the areas of inconsistency in respect of the views of other experts. And so, to provide a robust clinical review of Dr. Evans' opinions, setting out whether she agreed or disagreed with him, and, as appropriate, to provide an alternative causation for the collapse. As a former practicing physician, I find this a bit of a joke, because this assumes that there was only one way that any of the babies could have died, whereas the fact of the matter is that these were very complex pregnancies. Every single one of them was subject to what they called suboptimal care, and it is impossible to say to what extent the suboptimal care led to the deaths of the babies. But we also have to set aside a huge body of evidence here as well, which I presume was deemed hearsay as well. But I don't know, and that was the postmortems and the independent review of each case, which had already happened before Evans and Bowen came on the scene. And for the mere fact that these very detailed reports weren't collected by the proper procedure that establishes facts in a criminal trial, the information in these reports never reached the jury either. Now, we also have to consider here in the order in which these appeal court judges are setting this stuff out. They're saying here that Bowen and Evans had to provide detailed explanation of areas of inconsistency in respect of the views of other experts. Well, the other experts have to be the pathologists, the people who did the case reviews for the hospital management and the RCPCH itself. Because in this sequence of events, the expert witnesses who eventually went to court hadn't been appointed yet. In medicine and in science, it would have been essential to consider what everyone had said about the babies, not an obviously biased and partisan report or opinion of just two people who are not the most qualified people to give an opinion on why the babies had died. And here we see the rules of evidence, or whatever they're called in the law, a different approach to how you establish facts than would happen in a scientific or medical environment. And because of that, it lacks scientific integrity and serves a particular purpose, which is to create a narrative suitable for a trial, but not necessarily suitable for inquiry. And this is what I mean by it looks to me like the law just plays games. In science at this point, the potential for bias is off the scale. It would have been far cheaper for the police to approach 60 people and give them one file each and ask them to anonymously review it. And I'm pretty certain that there wouldn't have been a single crime found in any of the cases that Evans picked out and eventually filtered down. But the potential for bias just keeps getting worse, because Dr. Evans advised the police, this is paragraph 24, on the instruction of experts from specific specializations, and further experts were instructed and provided reports as set out below. And then it just lists all the people that were called to give evidence against Letby. So a team, really, of experts, all of whom were going to agree with Evans, and presumably over whom Evans had a degree of control. If he's advising the police, so he's an investigator as well as an expert, presumably he could have advised the police to drop any of these witnesses at any time if he didn't agree with what they were saying. I'm not suggesting he did do that. I'm just saying that that's where bias could easily show up. And it's not clear as well from all of this how much of this process did the jury know about. Did the jury know that Evans was the chief cook and bottle washer for this whole thing? I don't know, but I think they should have known. After all, was the purpose of this trial not to be fair from the outset, and naively, I suppose, based on a presumption of innocence? And even in 2019, there was more than enough evidence to make a conclusion that these babies had died from multiple causes, including sepsis, suboptimal care everywhere, and that, in effect, there really hadn't been any crime at all. And lawyers probably think that's okay, I don't know. But an honest scientist, or somebody who was going to get caught out in the end anyway, whether he was honest or not, would have abandoned this project long before it got this far. because it just doesn't smell right. And most people I know would have been embarrassed to be anywhere near it. And then we get to paragraph 25, which talks about the issues at trial. So 25, relying upon this body of medical evidence, the prosecution identified the various mechanisms by which it asserted that the babies had been harmed. The mechanisms were embolus, there we go again, caused by air being injected into the vasculature via intravenous lines. This was advanced as the sole cause of the collapse of baby A, baby B, baby D, baby M, and a contributory factor in the collapse of baby E, baby I, and baby O. And we will return to this again. And we get to section 2 of paragraph 25. Air forced down an esogastric tube. This was alleged to be the cause of the collapse and death of baby C, baby I, and baby P. And this is the bit that now causes a big fat problem for the lawyers, or at least it should do. Whether it will or not remains to be seen, because the chief cook and bottle washer, Dowie Evans, has since changed his mind about this. He no longer believes that air forced down an esogastric tube, or air and fluid, as he sometimes says, forced down an esogastric tube, is or was the cause of death for any of the babies. Yes, believe it or not, he has changed his mind. Now, the fact that he has changed his mind, if this was a scientific exercise, that would be the end of the story. Every word that Dowie Evans ever wrote or said in regard to this case would be put through the shredder, confined to history for all time. It would be the factual equivalent of Monty Python's Dead Parrot. But thus far, it's still on the books. Yes, the postmortems originally carried out on these babies are sitting on a shelf gathering dust, and at the same time, this proposed mechanism of death, which is quite fantastical, is now subject of recantation. Then we move on to paragraph 25, section 3, insulin poisoning. It was alleged that the bags of fluids being administered intravenously to baby F and baby L were adulterated by the addition of exogenous insulin. Now, we'll say it again, there is zero, none, nada, zilch evidence that this baby ever had insulin anywhere near it, apart from the minuscule doses that were prescribed earlier in their treatment. In the case of baby F, baby F and baby L are the product purely of supposition and invention, and we will return to these as well. Section 4, paragraph 25, overfeeding with milk, baby G, since withdrawn, I believe, and 5, trauma to baby E and baby O. Well, we certainly know that baby O was subject to trauma, very sadly, of a most catastrophic nature, but it had nothing to do with Lucy Letby. And so far, we haven't had any comment from prosecution service, the police, Dr. Breary, Dr. Jeram, or anyone else about the real cause of trauma in baby O, making the allegation for baby E, which is a bit shaky to begin with, even more unreliable. As a doctor, if I was presented with the evidence that Richard Taylor described in Mark McDonald's press conference, I would be horrified and frankly quite frightened that experts would make ridiculous claims that baby O had injuries similar to a car accident, whilst simultaneously ignoring the fact that someone put a needle into this baby's abdomen, unguided, without any point of care, ultrasound, or anything to make sure it was going into the right place. I find it terrifying that a doctor could be so incompetent as to miss that, or equally as incompetent as to ignore it. And I think the British public, who are the patients of the National Health Service, should be terrified too. For baby O, this was the personal equivalent of Chernobyl, an avoidable disaster from which there was no comeback. Terrifying. And then we get to paragraph 26, and paragraph 26 is just a list. Count 1, BBA, murder, embolus. Now we know the term is embolism, and from now on I'm going to use the term embolism, but everywhere it's written here, it's embolus. An embolus, as I've said before, doesn't kill you because the embolus is still moving, and because it's still moving, it's not called an embolism. And until it stops, we don't know what harm, if any, it can cause. So I will say embolism and not embolus. Count 2, BBB, attempted murder or embolism. Count 3, BBC, murder or venogastric tube. Count 4, D, murder or embolism. Count 5, murder, acute bleeding or embolism. BBE, BBF, insulin poisoning. BBG, 7 and 8 counts. Overfeeding with milk. 12, I, murder, or venogastric tube or embolism. Count 15, BBL, attempted murder, insulin poisoning. 16, M, attempted murder or embolism. 17, attempted murder, throat trauma. 20, BBO, murder, injury to liver or embolism. And 21, BBP, murder or venogastric tube. All very interesting. Then we get to section or paragraph 27. The prosecution maintained that the applicant's responsibility for the deaths and sudden collapses of babies could be inferred from a raft of circumstantial evidence. And this, for me, is one of the fundamental differences between science and the law when it comes to evidence. To a scientist, circumstances alone are nothing more than a bunch of correlations, which it's possible to interpret in multiple ways, all of which can only ever be opinion. In science, we establish the hypothesis from inference or deduction, and then we test the hypothesis. The test of the hypothesis is an exercise in disproving the basis for the hypothesis. And if your analysis falsifies any part of your theory, you have to junk it. You can start from scratch with more or less the same theory, but you're going to have to change some of the core assumptions from which you created the theory. The prosecution in this case is trying to tell the jury that there is only one explanation for all the deaths in the Countess of Chester Hospital, when that is simply not the case. Medicine as a science is not advanced enough to make diagnoses by exclusion, which is the backbone of Dolly Evans' argument, and which the other experts simply prop up, which we call bias. And the proof of that, unfortunately for Lucy Letby, is very simple, but it's happened after the event. And indeed, so weak was the circumstantial argument put forward for the conviction of Letby, it didn't actually take very long for the whole argument to crumble into dust. Why was it not put into evidence without any hedging or equivocation the simple fact that babies with haemophilia can and do bleed spontaneously, and this is taught in medical school so that people who are caring for the babies will be on the lookout for the problem. But so bad was the evidence in this trial that the expert said that this couldn't happen, Professor Kinsey, and the advocate made it worse by saying that the baby had mild haemophilia when the baby actually had moderate haemophilia. And the argument that the lawyers will now make is, well, the advocate can't create facts. But someone surely should have corrected him at the time. And the case is riddled with these inconsistencies and little half-truths, false inferences and deductions, that it is actually quite childish as a body of work. It looks and feels like the work of amateurs. And until we see in print the reports from the experts working with Mark McDonald now, you're not going to really know what the difference between a proper medical report is and this kind of crap. But when you do see it, it'll be very logical, very technical, very well structured. It will take into account every aspect of the care of the baby, including the very real circumstances of the filth of this ward, and it will produce two summaries. One will be a technical conclusion and the other one a simple and easy to understand conclusion. Paragraph 27 continues on by saying, the applicant alone was present on the unit at the time of all of the deteriorations and deaths and was the common factor in all of the cases. Well, that's not true either, is it? Because apart from the fact that we have since found out that Letby wasn't on the ward when certain events took place, which were core events for the argument of the prosecution, we also know from the previous paragraphs in this judgment that there was initially a much higher number of suspected collapses and deaths. And again, an honest doctor or scientist would want all of those in evidence so that we can make comparisons. Again, it's much easier to reach a logical conclusion if you have all the information. Darry Evans has since made so many ridiculous comments. For instance, he says that the babies that he excluded had died of the usual things that babies die from, including infection. But BBC and BBD clearly had infection, and yet they were not excluded, which is proof in itself of bias. I'm pretty certain when or if we ever see all of the other deaths, collapses or events, as these people call them, they'll be very similar to the ones that Letby was convicted of, because they died from the usual diseases that preterm babies get. And Darry Evans' claim that that was otherwise is not very convincing at all. Then paragraph 27 continues on to show that they haven't got a clue how a hospital actually works. The judges say she appeared to be fixated with being involved in events in the intensive care nursery and involved herself unnecessarily with babies who had been designated to other nurses, which was actually her role in the neonatal intensive care unit. As I've said before, designation and all this kind of thing is as much an administrative decision as anything else. Nobody is ever told, particularly on an ICU ward, but on any ward, not to get involved when there's an emergency. So this is just another piece of circumstantial nonsense. Paragraph 7 carries on. She created, it was alleged, false entries on certain documents to hide her activities, to provide her with an alibi, or lay the ground for invented explanations. But part of the reason that Darry Evans had to withdraw his ridiculous in a nasogastric tube theory was because Letby wasn't present when this alleged attack took place, and that happened in multiple other babies. So even if Letby had a real alibi, so biased was the case against her, she couldn't even use it. And here we have the judges fretting about Letby creating false alibis, which were likely easily explained by the fact that the nurses were run off their feet and clinical records were missing in a lot of the babies. But the appeal judges are also taking a very partisan view towards record keeping here, because it's easy to argue that Dr. Jairam created records and thus evidence after the event to lay the ground for invented explanations, most notably, but not exclusively, in baby A, when he claimed to see the pink flitting rash but never recorded it. What is that if it is not laying the ground for a different explanation? She retained and took home a large number of handover sheets as trophies of her crimes. The handover sheets, it continues, were confidential documents and should not have been removed from the unit. But many people bring handover sheets home because they're not really part of the record. They're a need memoir. And in the Countess of Chester Hospital, they were held in such high regard that we have a witness who was a nurse that worked in that unit, who has since given an interview to the Telegraph in which she claims that staff on the night shift in the Countess of Chester Hospital used to bunk off early and leave a handwritten handover lead pinned to the baby's cot where anyone could have picked it up. But this witness, who would have given a lot of insight to the jury about what was actually going on in this unit, was dissuaded from giving evidence against Letby because it might affect her career. Over 200 of these handover sheets were found under the applicant's bed, which logically means she was collecting trophies on babies that she hadn't killed, which means they likely weren't trophies at all. And then we get the Facebook searches. Letby apparently looked up all her victims on Facebook, but she also looked up 2,000 other people on Facebook, pretty much diluting any importance that this inference brings to the table. Letby looked up thousands of people on Facebook, and then we get the various handwritten notes were found at her home. One of those notes concluded with the words, "I am evil, I did this." The prosecution relied upon this evidence as amounting to a confession. So this is the supposed great constellation of facts that in isolation mean nothing, but when taken together, point conclusively to Lucy Letby as a murderer, despite the fact that every single one of these so-called circumstances has a perfectly simple alternative explanation. Before we go deeper into this, let's have a look and see what lawyers regard as circumstantial evidence, which to me seems anything that you can fit into a convincing story. It doesn't have to have any basis in fact. Its relevance can be inferred or deduced in whichever direction you want to take it. Now, because I don't know anything about the law, I will refer to a common source of information, Wikipedia. And it says that circumstantial evidence refers to any evidence from which one or more inferences are to be drawn to establish material facts. And it goes on to say that while there is no burden to prove every piece of evidence on a standard of beyond a reasonable doubt, in order to convict on a circumstantial case, a judge must be satisfied beyond a reasonable doubt that the only rational inference that can be drawn from the circumstantial evidence is one of guilt. But to a scientist, this is just a perfect example of circular logic. It's true because I say it's true. The proof of what I say is the opinion of someone who happens to agree with me, and this is sufficient to create a circumstance where I can generate fact. What it doesn't say is, in order to sustain the facts, I have to ignore a lot of other evidence, such as the findings of autopsies, hearsay reports from the Royal College of Paediatrics and Child Health, other expert reports that didn't find any evidence of a crime, and actual facts recorded in the notes that point to a different cause of death, for example, baby O, than the one given in evidence. And it goes on to say that circumstantial evidence is based on reasoning and inference drawing through probability. The judge must apply logic, common sense, and experience to the evidence. They must consider the inherent probabilities and improbabilities, frequently eliminating the possibility of coincidence. In other words, an exercise in Bayesian logic, which is advanced statistics, which we've been told is not part of the Letby trial. And it says here that a conclusion cannot be found without evidence, which is to say, it cannot be speculation. The strength of the inference made from circumstantial evidence depends on the relationship between the circumstantial evidence and the rest of the evidence. But what does that mean when the only evidence you have is circumstantial, which is what judge says? This is a circumstantial case. I'm confused. And if I was reading this as part of a textbook, I'd put the textbook back on the shelf and I'd go and look for another book, because I would assume that the author wasn't very good either at explaining things or understanding things. And Wikipedia goes on to say that the standard of appellant review, the standard of review of any instructions on the drawing of inference of knowledge in a circumstantial case, is whether the trier of fact, acting judicially, could reasonably be satisfied that the accused guilt was the only reasonable conclusion available on the totality of the evidence. Again, circular logic. How does that apply in a case where you don't allow certain evidence into court? Surely by its nature, the circumstantial nature of circumstantial evidence is altered by the quantity of the evidence that you allow. Had the jury read the RCPCH report, had they known that the ward was contaminated with a pathogen that is quite lethal and which the chief witness, Darry Evans, claimed in a podcast should have forced the closure of the ward. But he didn't tell the jury that. And by my reckoning, because only the advocate took evidence from Mr. Mansuti, the plumber, and neither of them can create fact. The fact of the contamination of this ward was never examined in the court, and as I see it, constitutes new evidence. But I'm sure the lawyers will find a way to get around that reasoning. The whole thing seems like a jumbled mess to me. For me, this is very reminiscent of Plato's allegory of the cave. It's a philosophical concept from, in my opinion, his greatest work, The Republic, that explores the nature of reality, knowledge, and human perception. The allegory, or the scenario, is a journey that illustrates the move from ignorance to enlightenment. The allegory describes a group of prisoners who are bound by chains to the wall of a cave, and they've been there since birth. They're bound to their necks and their ankles, and they're forced to face a blank wall, and they're unable to turn their head. Behind the prisoners, there's a fire, and between the fire and the prisoners is a raised walkway with a low wall. And people walk along the walkway carrying objects and cast these shadows on the wall in front of the prisoners. And this creates what Plato called the prisoner's reality, because the prisoners can only see the shadows cast on the wall and hear echoes of sounds made by the people walking behind them. And because they know nothing else, they believe these shadows and sounds to be reality. The allegory continues by imagining that one of the prisoners was freed and escaped from the cave. Initially, the bright light outside would be really painful and disorientating, but gradually the freed prisoner would adjust to the new environment. And eventually, Plato imagines that the prisoner would see the world for what it truly was. And that would include the recognition that the sun was the source of everything they see. And then the prisoner makes his way back to the cave, and he's temporarily blinded by going back into the darkness. But he attempts to explain the true nature of reality to the other prisoners, who are, understandably, initially at least, very skeptical and even somewhat afraid of what this guy is telling them. Of course, anyone is free to interpret the meaning of the allegory any way they want. But for me, it's, with relation to the law, as if the entire legal system was bound to the wall of the cave, and the judiciary go out of their way to make sure that either no one escapes, and most definitely no one gets back into the cave, to spread the good news that there's actually a lot more out there than you think. So they play this little game, which is not in the allegory of the cave, whereby they act as the gatekeepers of fact or reality. And by their methods of persuasion and use of circumstances and other soft data points, they can very much create a circumstance, situation, or outcome that is so far removed from reality, it's quite terrifying in a way. And one of the checks on the power of judges is the open nature of trials, that they're not held in secret. And in enlightened countries, there is no restriction put on the press. In fact, some legal systems allow television cameras into court, which I suppose is the ultimate in open justice. What the detractors of the Lucy Letby is innocent people fail to do is to see just how much the deck was loaded against Lucy Letby. The decision on what evidence to allow in, not to allow in, was, in my opinion, far too restrictive, particularly if the nature of your argument is circumstantial. Circumstantial cases in 2023, at a time of enormous technological progress, should be the weakest kind of case. And without all of these false inferences or multiple choice inferences, scientifically biased inferences, this case wouldn't have made it past the first hurdle. In order to sustain this conviction, it's necessary now to disregard so many very important facts that did not go into evidence. And this is a very serious problem for the credibility of these experts and the credibility of the courts. I can't see it any other way. In Plato's allegory, the fire is the source of elimination, in other words, of knowledge or enlightenment, but it serves only to create false realities and limited perceptions. And in order to escape the cave, all we have to do is recognize the limitations of our knowledge and the limitations of our ability to process information. There are two other books that I keep wandering back to in considering the Lucy Letby affair, both written by Nassim Nicholas Taleb, The Black Swan and Fooled by Randomness. The Black Swan deals with events that are unpredictable, rare, but very consequential. And these so-called black swan events play a much larger role in shaping our world than we realize. But apart from their unpredictable nature, for example, the last snowflake that lands before an avalanche starts, and that last snowflake provides sufficient weight to trigger the avalanche, but it's totally impossible to predict when it will ever land. But one of the weird characteristics of black swans is that despite their unpredictability, humans tend to concoct explanations for them after the fact, making them more plausible or easy to understand and therefore predictable when they're not really. They are completely random events that happen all the time. World War I is probably a good example of a black swan. And in Fooled by Randomness, Taleb extends his argument about the nature of reality to include the impact of luck and randomness as the foundation of events, rather than determinism or skill. We as humans tend to see patterns where there are none, and this creates false conclusions about causality. Humans tend to oversimplify things because we feel uncomfortable with ignorance. We would rather hold beliefs that are not true than not hold beliefs at all. Human beings are inherently very frail, as we all know, and we try to create structures in society to overcome these limitations. But unfortunately, in doing so, very often we rely too much on experts and not on common sense and our own intuition. I often wonder what the original jury in the trial think about it now. But of course, that's again something we can't know. But so far, as we're working our way through the preliminaries of this appeal that failed, I'm not very encouraged by what I see. The bulk of facts available to people now, but apparently not available at the time of this trial, completely pulverizes Darry Evans' theories. And without Darry Evans' theories, there is no golden thread and there is no case to answer. It's going to be interesting to see what happens in the new year. And we will work our way through this appeal court ruling and start to get into the meat of the matter in the next episode and see if we can unpick the illogical nature of all of this process over outcome. And to give you an example of why that's so important to me, recently I was asked to review a case by a colleague. This was a relatively young man who was complaining of back pain. And he had been complaining of it for quite some time, and The pain was getting worse, and he was now having to use controlled substances, morphine, to alleviate the pain. And even that wasn't working. Now, the colleague had been very diligent, and from the phone call that he made to me, it seemed as if he had followed the manual correctly, but he hadn't got anywhere. So I gathered together all the information he sent me and arranged to see the patient. When the patient came in, I took the history again. It was evident that he was in pain, and the examination of the patient showed that he had pain and sensory loss in the area of L3, so that's the third lumbar vertebrae. Now, as the nerves come out of the spinal cord, they come through each of these levels, from the cervical spine right down to the sacrum. And each of these levels corresponds to what's called a dermatome. And a dermatome is just a patch of skin on the body whose nerve supply originates from the spine at a certain level. And this guy was pointing to a problem in the third lumbar vertebra. His doctor had sent him for a CT scan, and he had written quite a long letter to explain to the radiographer and the radiologist what he suspected and what area of the spine he wanted to focus the scan upon. And he received back a report that simply said, no abnormality detected on the scan. This scan had been carried out about 2 months prior, and given the man's history, I found it hard to believe that he did not have some kind of pathological finding on a scan at L3. The next step was to get the scan itself rather than the report, which I usually do anyway, because they come on a CD and you can create an image and keep it in the file. And I was very surprised when I got the scan for 2 reasons. Number one, I had in front of me the letter that the doctor had written to the radiologist asking him particularly to look at L3, and the scan in front of me that did not include L3. So before I made the mistake of blaming anybody, I phoned the patient and I asked him, did he bring the original request form to the radiologist? And unsurprisingly or surprisingly, I don't know, he told me that in the morphine haze that he was in, he lost the original request, and he went back to the surgery and the receptionist gave him a generic lumbar spine x-ray request and not the original request. I phoned the radiologist, explained all this to him. He agreed to see the guy the next day, did a CT scan, and lo and behold, L3 was seriously damaged by metastatic cancer. And of course, the secretary had no idea that the letter was so important. She thought she was helping out by issuing him with another one because she knew he had an appointment the next day. And the doctor who received the report assumed that his request had been carried out, despite the fact that I told my colleague there was nothing that he could have done to prevent this. He felt very bad about it, even though it wasn't going to make a difference in this case. The condition could have been benign, and because of the delay in diagnosis, it could have had an impact on the outcome, leaving the patient permanently damaged because nerve injuries don't always heal. So this was a clear case where the process broke down. And what we had to do was re-establish a process that would be less likely to fail in the future. It's a very simple story. It happens all the time. But in this case, the fact that the man had secondary cancer affecting his third lumbar spine existed before it was discovered. And the process that we were engaged in failed to discover it, which is why there is an old saying in medicine that protocol has killed more people than smallpox. And the way that these lawyers go about describing medical events is really, really childish, simplistic, and nonsensical. So I hope you are as confused about the law as I am, but we're inching our way towards understanding how these people use reason and logic, and we'll carry on. in the next episode, where hopefully we'll get to a more substantive part of this judgment, away from just background. So I'll see you in the next episode.